Hello again from Fired Up. I'm your host for the show, Bob Irwin. We're broadcasting from Rigel Studios here in Las Vegas, Nevada. This show is about guns, related politics, and self-defense issues. I see what I'm doing. I got to learn to work this control. Fired Up is on our website, firedupwithbobirwin.com. A new show is posted every Thursday at around 5 p.m. Pacific time. New shows also appear on YouTube and numerous other media. The audio feed is rebroadcast for radio listeners Saturdays at noon on the Nevada Talk Network. You can check out KELY1230.com for a station in your area, 18 or 19 of them, AM and FM at the present time. If you have a question or comment, you can send me an email at bob@firedupmail.com. That's bob@firedupmail.com. Or leave a message on my recorder in my office, 702-257-1060. That is 702-257-1060. If you leave contact information, I will respond by email, text, or telephone. Any question directed to my guest will be forwarded, or in the case of today, if the guest has his own direct, which he will get into in just a second. There are several hundred defensive uses of firearms every week in the United States, rarely covered by any mainstream media. So we try to present a few of those for our customers' education, our listeners' education. I see what I'm doing. Most are good shooting, some are questionable, sometimes they're just plain wrong, but they're all educational for people who own firearms. That's the point, that you can learn. Warning here is individual incidents are generally adjudicated under local law. The advice given might not apply to listeners in different jurisdictions. The incidents are as reported, except as our policy, the names of the participants are omitted. My guest today is Nevada and California attorney Donald J. Green, who we will get to in just a second. First, I want to do, the way I wrote it was first up on Fired Up. Last week, I did a show on the U.S. Federal District Court Judge James Mahan has on the ammunition supplier to the shooter who did the shooting October 1. He's been working, trying to get a trial date set and the rules. We went over in the last show about how we get a non-biased jury who's not going to blame this guy who sold the ammunition for the deaths and so on. Anyway, because both sides have now requested a continuance, because apparently is going to trial. And the trial is, of course, whether the accused illegally was selling armor-piercing, tracer, and incendiary ammunition to this guy who turns out to be a mass shooter afterwards. Both the prosecutor and defense counsel requested more time, is understandable. The trial is now reset for December 11th, 2019 here in Las Vegas. So that is the update on the old news. If you watched last week's show, this is going to be a whale of a case. I may be able to get Dawn to comment on it a little bit later in the show. Anyway, my guest today is California and Nevada attorney Donald J. Green, and he's a regular guest here and a true gun law guy. So if I can let him introduce himself and give him a little bit of your background,
Okay.
Don.
Thank you, Bob. Again, your listeners and your viewers may know me. My name is Don Green, for those who don't. And the emphasis of our practice is firearms litigation, legislation, administrative procedures, working with the ATF, FBI, background checks, TSA seizures of weapons, ammunition sales, you name it. If it's firearms related, just give me a call. My 24-hour cellular is 702-409-8239. And we have just printed up we got these little index cards. We usually pass them out at gun shows. And this index card shows the Nevada law effective June 8, 2019 from the Nevada Administrative, based on the Nevada Administrative Code. These are all of the 30 states in which Nevada recognizes as of June 6, 2019. Now, the legislature each year, by law, must update or change the reciprocity of those states which have concealed weapons permit, which are allowed in Nevada. This year, there are no changes from 2018, but it's still, if you want one of these cards, go ahead and email Bob or call me on my direct cellular at area code 702-409-8239. Let us know that you're a viewer or listener and leave us whether it's a post office box or a mailbox, etc., or your home. Let us know and we'll mail you one of these free. It's got my contact information. But again, this is from the Nevada Revised Statutes. Is actually from the Nevada Department of Public Safety website. And that's effective June 6, 2019. Thanks.
All right. Now that we've cleared up last week's show and that, this first story is from WPXI 11 News in Crescent Township. This was reported on June 19th, which basically had just happened from the time we're doing this show. Crescent Township, Pennsylvania. The Allegheny County homicide detectives say officers were called to a home along Star Road just after midnight. When officers arrived, they found a 22-year-old male shot in the doorway of the home. Allegheny County investigators told Channel 11 the 22-year-old had been drinking and was dropped off in the area by a friend. He showed up at the home because he thought a girl who he knew lived there. The guy's at the door, knocking on the door. The homeowner called 911, and while he was on the phone with dispatchers, the 22-year-old began kicking at the door and screaming at the homeowner to open the door. The homeowner told police he answered the door, told the 22-year-old he was at the wrong home. The resident asked the young man to leave. The would-be intruder then became more aggressive by kicking down the door and then trying to enter through that door. The homeowner then pulled a gun and shot him multiple times. The would-be intruder was pronounced dead at the scene. The homeowner told police he felt threatened for himself, his child who was there with medical needs, his elderly mother he cares for, and fired the shots in self-defense. Channel 11 followed investigators as they proceeded to the scene. Investigators spent at least 4 hours gathering evidence from the neighborhood. A neighbor said he feels bad for the young man's family. He probably didn't deserve to die, but he thinks the homeowner was justified under the circumstances. As of this report, no charges have been filed against the homeowner. This is early in the case. I want to make a couple of comments, and then I'm going to turn Don Green loose on this. First off, this is really crappy police procedure to allow media to follow the investigators searching for the scene for evidence. I have never heard of this. The neighbor's opinion, while being supportive, of course, has no actual bearing on the case. Listeners got to beware, because your neighbor comes on TV and says, I think Fred was right. Nobody in the jury is going to care whether you think Fred was right. So it makes nice news stories, but it doesn't mean anything. Here we have an intoxicated individual at the wrong house. Everything was done that could have been done. Locked doors, warnings issued, 911 was called. Sometimes there are simply no other options available. Now, I'm going to turn this over to Don Green.
Thank you, Bob. The homeowner was justified in shooting the intruder. The homeowner at the beginning was probably not threatened with great bodily harm or injury, but he did the right thing by calling 911. But while on the call with 911, the intruder started screaming and kicking the door. The dispatcher at 911 could probably hear the commotion, and then the homeowner is answering the door. The would-be intruder is becoming more aggressive. He's kicking down the door, and at that time, the homeowner pulls a gun and shoots the intruder. Because at that moment, let's focus on that moment. At that moment, it's when the homeowner felt the threat of great bodily harm or death. The key word is or. It doesn't have to be threatened with death. And I've heard attorneys say, oh, you got to be threatened with death. No, you got to be threatened with a great bodily injury or death. So the attorney for the homeowner, if he gets one just in case, should focus on that very moment. And that moment is very important because that's what, if they do file charges on him, you've got to compress this case and get it to the point that, number one, castle doctrine. Two, stand your ground, because he was where he was supposed to be. And there was the threat of the great bodily injury or death by the constant screaming, kicking by a 22-year-old male, regardless of his intoxication. He could have still hurt the homeowner, and the homeowner was justified because of protecting his home, the child, and the elderly mother.
I agree. This is unfortunate. We talk about these cases often, and sometimes you do basically everything possible right, but you can't control the opposition. And crazy people, drunk people, 5% of the criminals simply are going to continue anyway, no matter what you do. It isn't logical that they'd walk into gunfire, but they do. If your house door gets kicked in 19 out of 20 times, when you call 911 and give the guy a warning, he's going to leave. The other 5% are the ones why you really have the gun. Anyway, we are there with that. I'm going to Don requested some time today to talk about updates on firearms laws. There's some interesting things going on here, and he may want to comment on the first case I was talking about from last week's show, where we have the ammo supplier now being tried with a jury in Nevada, which is going to get to be a really complicated case. So anyway, I'm going to turn you loose, Don, and I'll jump in whenever.
Okay, thank you. As to the cases pending in Las Vegas on the man who allegedly sold the armor-piercing ammo and tracer incendiary ammunition, to me, my argument to the jury is they needed somebody to blame. So they followed what happened in this case. They looked at receipts. They looked at videos. They checked everything out. And they found that this man sold something which unfortunately ended up in a shooting in Las Vegas. Ladies and gentlemen of the jury, if I sell a brand new 2019 Mercedes in cash to a couple from California, and the couple from California go to a pub here in Las Vegas and get stinking drunk, and 20 minutes later, after they're drinking, they drive the Mercedes and kill several children at a bus stop. Am I responsible? Answer, no. But somebody's going to need to be a scapegoat. Well, they sold the Mercedes for cash. And in this case, I think, again, my opinion, is that the salesman, the ammo dealer in Arizona, is being tried because they needed to blame somebody. You know, no one's ever been tried on this case. And there's a shooting with .223 caliber, approximately 2,700 feet per second, shooting into glass panels at the Mandalay Bay, which weigh 800 pounds each. You'd have to shoot that so many times, and nobody reported the shots. Give me a break. That's my take on that. Now, for the California people especially, listen to me very carefully. This may help some of you. And this is on the California restraining orders. When a California restraining order is issued, many of them are issued ex parte. That means without you having notice of it, and then you get served with it. But look at this. Under the federal law, and that would be 18 United States Code, Section 922G8, the federal government requires this, and federal law is supreme. Under federal law, individuals are prohibited from receiving or possessing firearms if they're subject to a court order which was issued after a hearing for which they received actual notice and had an opportunity to participate, number one, and, not or, and it restrains them from harassing, and either finding that they represent a credible threat to the physical safety of an intimate partner, etc. It requires those three things, which is not required under California law. So in Nevada, with our new red flag law, and someone says, like an ex-wife says, that my husband is a threat and he's got guns, is that sufficient for the police to go under the new red flag law to go to his house and take his guns? Yes or no?
That is not sufficient rationally.
Yes. So what happens when you get to this gun court? What is the standard of review?
Yeah, that's the problem here is, and divorce lawyers have been doing this for a long time.
Mm-hmm.
And I know divorce lawyers who will say to their female clients, or the male client in reverse cases, that didn't you ever feel that your husband might hit you? Well, no. Well, did he ever raise his hand like he might hit you? Well, yeah. Did that make you afraid? You know, because we can then stop him from having firearms off the record here if you'll just say you were in fear of great bodily harm because you think he's dangerous. This will go to a judge or not. It'll go to the police officer on the scene, depending on which jurisdiction you're in. And he will say, well, I'll do my best guess and let the guy keep his guns. Mm-hmm. He's not going to do that. He's going to err on the side of public safety.
That is right. That's correct.
And the judges, unfortunately, will end up generally doing the same thing. This requirement Don's talking about, that you have to have a credible hearing where you have notice and you can represent yourself or send somebody to represent you, is a much, 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 much better system. If you choose not to go to that, whenever you choose not to go to court, trust me, I worked for years as a bailiff, you choose not to go to court when you're supposed to, game over, you're done.
That is correct. And for your California listeners, be very wary of the following. There are 7 statutes in California which would allow for the taking of your weapons. The California Civil Code, or the California Code of Civil Procedure for civil harassment, the California Code of Civil Procedure for employers who think their employees are going to be a credible threat, the California Civil Code for schools, the California Family Code, the California Penal Code for court orders against a victim or witnesses, you can have your weapons taken away, the California Welfare and Institutions Code for protective orders in response to elder or dependent adult abuse, and the California Welfare and Institutions Code on juveniles. Now, these gun violence restraining orders, the thing is that they lead to believe that it's only an immediate family member. But look at the statute in California. It's very expensive to any spouse by marriage or domestic partner, parent, child, or any person related by consanguinity, that means by blood relation, or affinity within the 2nd degree. That would be like your aunt and your first cousin. Or any other person who resides in the household, a guy you just kicked out because he didn't pay the rent. Or within the prior 6 months, regularly resided in the household. Again, a guy who kicked you out and you sue him in small claims court for the rent, guess what? He's going to claim that you've done something about his firearms. Now, I want to also point out very quickly that for all you people in California, and this is the law. Now, there are exemptions in California for concealed weapons permit in your own home. Now, to have an interest in the house, in the property, you must show the following. You must show the following. 1, you have the right to exclude others, and you control the activities which control on your house. If the residence or private property in which you wish to carry a concealed weapon meets this test, and you are over the age of 18, a lawful U.S. citizen or resident, and are not otherwise prohibited from possessing firearms, you may lawfully carry a handgun in that place. If the residence, private property, or private business is located in a non-public place, then you may also carry the handgun carried concealed. be very wary. And what you have to do is take a look at, there's a case called People versus Barella. It's reported at 234 Cal App, third supplement, page 15, and that's a 1991 decision. The decision is over 30 years, is almost 30 years old. So that's in your favor, but it's been revamped by the California legislature. So, and then also, I'd like to point out, for all of you people, there's a bump stock ban out there, but that bump stock ban does not affect arm braces. And on June 25th, 2019, the Bureau of Alcohol, Tobacco, and Firearms, in a letter to a gun dealer, but it's public record, stated that, remember that there was a question as to whether if you have the arm brace, whether it now creates what's known as a short-barreled rifle for which you need a special Class 3 permit from the Bureau of Alcohol, Tobacco, and Firearms. But if it is a true arm brace and not a bump stock, then according to the Alcohol, Tobacco, and Firearms and Explosives, as of June 25th, 2019, and your listeners take note of this, and you can call me on this. Get a piece of paper and a pencil right now. When a device is operating as a stabilizing brace is attached to the firearm via folding mechanism, the overall length is measured with the brace in the folded position. So all of you people who've got that permanent arm brace, there may be a problem. But if you have one that folds to the side or folds under, then the overall length is measured again with the item folded under, not attached. If you've got the permanent one, that's going to be a problem because you may have a national firearms weapon, because it says that it may, the stabilizing braces may be assembled as firearms as accessories designed to assist with the operation and use of certain pistols or firearms or shotguns. However, stabilizing braces are merely accessories and not relevant to the classification of the pistol. But once it's permanently on there, then there may be an issue. That's the updates right now.
All right. We're going to, I want to get a little bit further into something else on California. What I'd like to do is run our little bit of commercials now. We're about halfway through the show, and get those up on the screen, and we will then talk to Don about another issue. This, we do this in a series of slides. This is a new sponsor of mine, Freestyle Martial Arts. They are about the best martial arts school I have ever seen in my life, and trust me, I've seen a lot of them over my long time. Freestyle Martial Arts can be reached at 702-551-9009. They're located actually about 500 feet from my house, if you could fly that way, at 5693 South Jones Boulevard, Suite 103. You can find them at Freestyle MMA LV. FreestyleMMALV.com. I would encourage you, if you are looking for classes to defend yourself, this is the place to go. He trains UFC fighters. Gokar is just an amazing individual. We are, the next slide says, it's a promo for CCS Gunsmithing. They're 702-265-1732. The gentleman that owns it is on the show quite often. He's on Rainbow Boulevard near Sahara, 702-365-1732. And Jerry Creed, my old friend who he's an estate planning lawyer, but he specializes in gun trusts. If you have a Class 3 especially that you want to pass on to your heirs, you need to get a hold of Jerry Creed. He's at 702-806-7777. 702-806-7777. He's out in Summerlin at the moment. Give him a call. Oh, and then we have a gun lawyer, Don Green. Yeah. Don Green is an attorney here, licensed in California and Nevada, who does real research on real cases and really fights for his clients. I would suggest calling him. He is top of the line here. And Maggie Mordaunt, CCW Maggie. You can look up Maggie on the internet. Just Clock CCW Maggie. She runs all sorts of training classes for NRA and for ladies only and so forth and so on, multi-state CCW courses. She's teaching all over the world. Last I heard, she was in Guam teaching Marines. She and her husband do great training. Their number is 702-375-5900. 702-375-5900, or you can find her at www.hpptraining.com. Just look CCW Maggie. You'll find her all over the internet. That's the easy way. And we have Ricardo's, my favorite restaurant. When I'm not here, I'm eating something at Ricardo's. The guy is a wonderful supporter of conservative and pro-gun causes also. But they have meetings there, meeting rooms, all sorts of things. Ricardo's is a great place. It's at the corner of Flamingo and Decatur here in Las Vegas. You can call them at 702-227-9100. Great place to eat. I love their food. My wife's is better, but their food is really close. That'll keep me out of trouble, right?
Yes, sir. Yeah, theoretically.
Theoretically.
Yes.
While we're on these firearms laws, with the question I want to ask is, we're now in the position where California has passed this quantity buying limit and requiring a background check when you buy ammunition from a dealer in California. And with rather strict, you do a background check and fill out a form like a 4473 and so forth, under penalty of going to jail. When we have gun shows here, like we've got one coming up in a couple of weeks, we're going to be at the convention center. I expect that ATF and other law enforcement agencies, as they do with fireworks sales, are going to be watching people load ammunition in their car when they've got California plates. And they will then drive to California, and when they get stopped at the fruit inspection, they can be asked, of course, and they usually do you have any fruits or vegetables or drugs or whatever in the car? Sometimes they'll come up with a laundry list, and they will already have your plate tagged, of course, knowing that you just bought ammunition in Las Vegas that day or the day before. And you say, no, I don't have any of that in my car. Is that probable cause to search the car when he has reason to believe that you're lying? Mr. Green.
Well, the issue is lying. Do you have ammo in your car? Yes. Stop. What is the purpose of that? If he already knows, he's only getting you to try to lie to lure you into that lie. Here's the point. About 15 years ago, the U.S. Supreme Court issued a decision. It's called City of Indianapolis. I cannot remember, it was City of Indianapolis versus Brown or something like that. And here's what happened. The City of Indianapolis had created a program that when they had these checkpoints in the city, they were going to, during the day, they were going to search every 10th car or every 15th car. And at night, every 10th car, something like that. And it went to the U.S. Supreme Court, and the U.S. Supreme Court struck that down. Now, fast forward to 2010, just outside of Kingman, Arizona, going northbound on 95, just before you get to the lake. Every car has to pull off to the side of the road, similar to California. And it's a checkpoint, but the checkpoint is run by Wackenhut Services on contract with the Mojave County Sheriff. During the day, they search every 15th car, regardless. And at night, they search every 10th car. The point is that in that particular case, is it a violation? I would say yes. Now, the ammunition is legal in the state of Nevada. Right. The ammunition may be perfectly legal in the state of California. And note that the ammunition was not purchased in the state of California. So once you cross the line, does California have the ability to regulate the ammunition which is perfectly legal in another state? I said it's a violation of the Interstate Commerce Clause, for which Commerce has plenary jurisdiction over interstate commerce. Now, can California regulate bringing in assault rifles and 50 caliber BMG? The answer is yes, because there's a specific statute. But if I buy the information, excuse me, if I buy the ammunition in Nevada and it's legal, and I'm going into California, these aren't oranges. The oranges, maybe have disease and insects or whatever. Anyway, so I think that the interdiction stops are going to be there's going to be a lot of litigation, and the government's going to say, well, it's for government, it's for safety. California's going to say for safety, and Don Green's going to say it's a violation of the Commerce Clause in the Constitution.
And the question is your client going to be in jail until the trial starts?
It's possible, depending on how much.
When you're walking into a court case, be respectful to the officers. Don't say something like, you can't take me to jail, you jerk, because he will find a way to do that. So be nice. He's enforcing a law that he thinks is valid, and you're not going to win your court case with the guy standing next to your car with the handcuffs. So that being said, we're going to wrap up today. I want you to check out our recent shows at firedupwithboberwin.com. You will find older shows being added there, here and there. We're getting there. The commercials keep us on the air, so please pay attention to those slides we were talking about and support those people. We'll be back next Thursday on our website, firedupwithboberwin.com, and on YouTube at the American Guns and Glory Network, as well as when you're watching media, please click subscribe, and the new shows then will go automatically to your computer every Thursday evening. Check out our logo merchandise. We sell hats and books and shirts and things to keep us on the air at firedupwithboberwinstore.com. Thank you so much for watching. We appreciate you being with us today, and we'll see you next week. Don, I know I can get you to come back next week.
Yes, sir.
So we'll be at it again. Don't miss it. Thank you.